You are listening to A State of the Union, Estate Planning Made Simple, with your hosts, Brad and Zach Wiewel, from Texas Trust Law in Austin, Texas.
Hi, I'm Zach Wiewel, and I'm joined today by Brad Wiewel. We're talking about blended families today, and we got a lot of fun stuff to talk about, a lot of issues to talk about. But I guess first, Brad, could you define what is a blended family?
Well, Zach, I'll start by this. I think most people know that people get married, they have kids, they divorce, maybe somebody dies, they remarriage. It's that kind of thing. It's taking a family that is not now, quote, a traditional family, and because of the entry of another spouse, another, quote, parent, kids, that's blended, and it can be a wonderful, fantastic thing. It can be a really, really hard thing when it comes to estate planning.
What do you think makes it hard with estate planning? What's one of the main things that makes it tough?
Well, one of the things that makes it tough is the assets of both spouses, because one spouse brought in some, another spouse brought in some, and in Texas we have community property, which seems like, gosh, how hard could that be?
Well, it turns out it's really hard.
It's really hard, Zach.
So let me go ahead and define what separate property is. So community property is all property acquired during a marriage. So if I'm married and I buy a house, I get a salary, that's community property.
Could I amend that?
Sure.
While you're living in a community property state.
Correct. Texas is a community property state. Not every state is this. Most states actually aren't. But we are Texas Trust Law. We're talking about Texas law. Separate property, on the other hand, is property that you either bring into the marriage or property that you acquire during a marriage through a gift or through an inheritance. What's the issue with bringing separate property, though, into a marriage, Brad?
You know, Texas is a fantastic place. We have excellent laws on many, many things, not so much this. When you bring separate property, again, what Zach mentioned, property you bring into the marriage, property you inherit, property you're gifted by somebody, that is your separate property. And most people think, well, gosh, I'll just take my separate property because I want to keep it separate from my spouse. And
sure.
They're going to keep theirs separate too. We're going to just have two big piles we'll draw off as we need it. And I'd go to the, I don't know what, financial advisor, open an account, Brad Wiewel, separate property. Great, it grows, it changes, that's still my separate property, right? Not so much, not so much. Many states, there are only 8 community property states. In about, I think, 5 of them, the rule is income off my separate property is my separate property. So dividends, interest.
Rental income.
That's exactly right. Mine still stays separate. If my estate grows, so my stock portfolio in Dell grows from $1,000 to $1 million, all that growth stays separate. But any income off of anything is community property, and now we have a problem of commingling.
So commingling is basically you get that growth, that rental income, or that dividend that's coming out. And when you deposit that growth into that same account, you're commingling it. It's kind of like you're shaking up the whole account, and now there's a strong argument that now the entire account that used to be separate property is now community property, which causes an issue. The issue is it's hard to determine what's community and separate property, and Texas law has a presumption that all property is community property unless proven otherwise.
And proven by a really strict standard, clear and convincing evidence.
Yeah.
So it's a hard standard. So the problem is that people get married, and second marriages, third marriages, whatever. They think it's separate. Something happens to the marriage. They get divorced, or somebody dies, and what they thought was separate isn't separate, and it causes a real problem, of course, in divorce, but also at death, because now we have to figure out who's who. Okay, so it's yeah.
So let's talk about what happens whenever someone in a blended family dies without an estate plan. Because we see that all the time, and it's a huge issue. So let's say they didn't do a will, they did not do a trust, they die without a will or without a trust. What happens then, Brad?
You know, Zach, statistically, 70% of the people that die in Texas will die without a will or a trust at all. And as you know, in a blended family, this is probably the worst news we can deliver. If the person who died, because we're on the death side of things, not the divorce side of things, didn't have a will, then the money that they had, if they have children by a prior marriage, will go to the children, not to the spouse.
I had a surviving spouse come into my office, and she told me that her husband, brought a kid into the marriage. Then they bought a house together after they got married. And the issue with that is he died early. He died in his 40s unexpectedly. And what Texas law says is that she now owned her half of the house, but his half of the house went to his kid. And she had to use the life insurance money that she was just hoping to live off of to buy his kid out of his half of the house. And it was very awkward. It took a long time, and it's messy. It's very messy.
It's the worst thing because you're grieving. Mm-hmm. The loss of your spouse, you just lost half the income. They died. Mm-hmm. Now you've got a potential fight, and many times a real fight, over these assets. So the simplest cure, mm-hmm. Do a will, do a trust.
Do anything.
Do anything, right?
Please.
God bless you.
We wrote a book on this, the Texas Estate Planning Handbook. If you flip to page, I think it's 86, it has what the Texas law says is your last will and testament if you die without a will. Because even if you die without a will, Texas law imposes a will on you. And that's what we've been talking about, is what the law says to do whenever someone does not have a will. So if you don't have a will, you don't have a trust, it's vitally important to get one, especially if you're in a blended family, because you write the rules with a will or with a trust. You tell the person where your property goes. They're all customizable documents exactly to what you want. That's why it's so important to get a will or a trust in place to provide certainty to you, your spouse, your children, whoever there is that you want to receive money. Certainty is the name of the game.
Great.
Brad, can you talk about probate homesteads too?
Ooh. Holy cow. Probate homesteads. This is an obscure thing. I mean, the law is just, by gosh, in this area, and probably most areas, obscure in certain really vital points, and this is really a gigantic vital point. So it's a house. If a couple gets married, and let's say the house was his before they got married, her before they got married, they moved in, and I don't think we'll have time to talk about common law marriage here today.
We might have some time to talk about common law marriage.
That's another whole deal. But they get married, formally married, and it's his house, it's her house, and the spouse whose house it is passes away. And where does the house go? Well, if you're the surviving spouse, even if it was your deceased spouse's separate property, you get to live in that house rent-free the rest of your life.
Now, the heirs might be kind of waiting around for you to die or for you to move out.
Sure.
But they can't kick you out. And that's the point.
Right. It's surprising, though. So we're going to take it from another perspective. We sometimes get the kids in here. Mm-hmm. And Dad just remarried a couple of years ago, and this person, the wife, the new husband, we really don't like. And the largest asset of the estate is the home. And how do we access that? How do we get her out of the house? How do we get him out of the house so we can sell the house and enjoy some of the inheritance? And the answer is,
good luck.
No can do. So it's this stuff is hard, depending on, again, the perspective. If I'm the surviving spouse, this is a great thing. Mm-hmm. It's a really good thing. I'm living there, rent-free. Now, who's going to pay the taxes? Who's going to be insured? Who's going to pay the repairs? Those are other issues. But I can't be kicked out. But if I'm the kid, that seems totally unfair. And maybe this new spouse is dramatically younger than Dad, and maybe they'll outlive me. So I never really get to see my inheritance. So there are some things that can be done to minimize the impact of a probate homestead if you're on the kid's side of life, or maximize the benefit of the probate homestead for the surviving spouse.
Mm-hmm. I'm going to go ahead and talk about common law marriage. It's something that only a few states allow for, but it causes a lot of issues. And it's so easy to slip into. So common law marriage is basically without having a formal marriage ceremony, without going to a courthouse, you become married. Now, Texas law allowed for common law marriage back when Texas was founded because it was hard to go to a courthouse or to get people together for a ceremony because it was a rural community. And so they allowed people to become common law married. Now, there's 3 requirements for common law marriage. First is you have to hold yourself out as married. This is my husband, this is my wife, this is my spouse, to like a third party.
And by the way, now we have same-sex marriages too. So this is my husband, this is my wife.
Applies equally to that.
Applies, it does.
The second requirement is that you have to subjectively believe that you're married. That's hard to prove. So we look at that through actions. We look at that through like a joint tax return. We look at that again through what other people would have thought if you were interacting with your spouse with them. Now, the hardest element, also the easy element, is cohabitation. Now, cohabitation means exactly what we're saying, living with someone. But there's no time requirement in Texas law for how long you have to live for someone. It's not 6 months, it's not 4 months, it's not 5 years. It's a period of time. Could be one night, we don't really know. Again, it's one of those things. You could slip into common law marriage in one evening potentially. And the thing is, once you're common law married, it's extremely hard, if not, it's actually impossible to get common law divorced. It's not a thing.
You're married. And the law just says cohabitate. It doesn't say for how long. So this is, Zach and I do a lot of speaking. And we'll bring this up to a crowd of people, and you'll hear some people go, huh, because it can happen. We've got stories. I don't think we have time here to go through all the stories, but it's a really big problem. So if you think you're common law married, you certainly may be common law married. And if you've got kids, they've got kids, now you got a blended family. And Zach said it, and let's repeat it. There is no common law divorce. You have to file a divorce, you go to court, duke it out, whatever. That's the only way you can get rid of a common law marriage.
Now let's talk about partners. So you're not married to someone, but you're just living with them. And the issue with just living with someone but not being married to them is that when you die, you're a legal stranger to that person.
Right.
If they don't have a will or they don't have a trust, they don't get anything when you die. If you have a will or a trust, you can say, hey, I give my house, I give my accounts, I give whatever to this person. But in the absence of one of those, they're not going to get anything.
And there's no probate homestead for partners.
And so we see this happen from time to time where one of the partners dies and the other partner didn't have any assets. And well, Texas law says give the assets to that person's family, and that partner's not that person's family. And so failing to plan for this specific situation is really planning to fail. It can impoverish a person you might have lived with for 20 years.
Right. We've just seen this so many times, and it's just so tragic. And you think, gosh, it should all go well. Now, what we've also seen is the wealthier the wealthier partner dies, and the children are anticipating the inheritance because maybe there was a will or a trust that left it all to them. Maybe this is before they moved in or after they moved in. It doesn't really matter, because if you're not married, Zach said it, you're a legal stranger. And so the impoverished partner goes to see a lawyer and says, well, you know, golly, I'm impoverished now. I lost my partner. I got these kids biting at my ankles. What can I do? And the lawyer may suggest, well, let's just claim you were common law married. And now, welcome to court. Welcome to court. This is going to be long, ugly, expensive, and risky.
Yep.
So this is the kind of thing that we recommend, and we have been, I think, been successful with this.
Yeah.
Urging our clients that are living together to go ahead and get married and do a prenup, for goodness sakes. You want to keep it separate, we can do that, but you're much better off under Texas law married than just a legal stranger.
So let's go ahead and switch gears. Let's talk about children in a blended family. And one thing I just want to bring up really quickly is whenever there's minor kids in a blended family, it becomes hard to designate the guardian of what's called the person, who that child's going to go live with. in Texas, every state is very against terminating parental rights. There's got to be a good reason to do it, or that other parent has to consent, and most parents do not consent. And so in a blended family, the child might live with you and your new spouse for 2 weeks every month, or 3 weeks every month, or most of the time. But the thing is, if that first spouse dies, the one that you're married to, the other parent has first dibs. They still have parental rights, and there's not much we can do about that absent a termination of that parental person's rights. And so we're talking here about guardian of the person. But Brad, can you talk about guardian of the estate and some other options that are out there for money purposes?
Sure. So again, let's repeat what Zach said. So if I die and I was married and my ex-spouse was the other parent of my children, I die, they go straight to that person. I can have a will and say, no, they go over here. I can have a trust, say, no, they go over here. Doesn't matter. That parent gets it unless you go to court and prove somehow that they were completely horrible as a parent and they should stay with perhaps the new spouse. Money, again, same problem, same issue. The money is going to go, if I die without a will and I've got kids from a prior relationship, my money goes to those kids, not my partner, not my spouse. No planning, could have, but I didn't do any planning. So the money is going to go to the other former parent, and the other former parent gets to manage the money. And that is, in my experience, Zach, about the last thing anybody would want. I do not want my ex managing my hard-earned money that I've left my kids, but they get to, unless, again, they can be proven horribly, horribly wrong. Now, they become a guardian, which means they're under the control of the court. The court will require, reports and things like that, at least annually. But again, unless you like spending money on lawyers, this is a rough thing. So with a will well done, with a trust well done, you can't stop the kids going to your ex, but you can stop your ex getting control of your money. And you can set up a little trust for your kids managed by
whoever you want.
That's right.
Yeah, whether that's an aunt or an uncle, whether that's by your new spouse. But again, if you do planning, if you do a will or a trust, you set the rules. And I hear this all the time. I do not want my ex-husband, I do not want my ex-wife touching any of my kids' money. Well, again, doing a will or doing a trust is the way to do that. Because if that parent's not mentioned in that will or that trust as the person managing the money, then they have no right to manage that money. And all that money really is going to go for the benefit of that child. Now, you also avoid some of the more onerous parts of a guardianship because it's more private too, because it's in a trust. It's not necessarily court supervised. It's supervised by the person you trust to manage that money for that young child. Does that make sense, Brad?
Makes sense, Zach. It makes sense. And I think we're going to talk about one more thing. We're going to have another episode here. We go in a little more depth on finances with blended families and custody issues with blended families. But this is the hardest part ever. And you got two choices, ladies and gentlemen. You do the planning, you don't do the planning. It's not crazy expensive. It doesn't take forever to do it. You just gotta do it. And I think one of the things I'll offer at this point is here at Texas Trust Law, we offer a complimentary consultation. That means free. You can come in, talk to one of our lawyers, and we'll give you some direction on this stuff. But boy, don't be, I'll use a harsh word, don't be an idiot, okay? This is too big of a deal to just kind of leave to chance and leave to lawyers. And that's just what will happen if you don't do the planning.
Let's go ahead and talk about another issue now. Let's leave the kids aside, or minor kids aside. Let's talk about, again, in a blended family, you can't really control who dies first. Will the husband die first? Will the wife die first? Who's going to die first? And the issue is, in a blended family, you're both bringing assets into that family, or you're both acquiring assets as a married couple for that family. But the thing is, if when you die, and let's say you have a will and you give it all to your surviving spouse and you give it all to your surviving spouse in that spouse's own name, okay, well that works. That protects the surviving spouse. It gets the assets to him or her. The issue is that if you give it all in that surviving spouse's individual name, that surviving spouse could change their will.
Right.
They could give their money and your money to whoever they want. They could give it just to that spouse's kids. They can, for that matter, give it just to your kids. They can give it to a charity. They do not have to provide for your children when you leave it to a surviving spouse individually.
Right.
Again, this is a plannable problem, but you have to do the planning. So, Brad, go ahead and talk about remarriage protection, what all that means.
Whew, Zach, holy cow. Well, as Zach was saying, we can do, and we do, plenty of simple wills. It's all yours, honey. It's all mine, honey. It's simple. It is not simple when somebody dies necessarily because we have to do a probate, but it is simple from the upstart, and it is a light year better than anything else. But as Zach just pointed out, if I get it all in my name, and maybe my spouse had kids, and maybe I have kids, or maybe we have kids together, it doesn't really matter. I'm on the honor system, and the honor system says I have promised my deceased spouse that I'll make sure the children get the money as we both agreed in this will. But my spouse is dead. Nobody's telling me what to do, and if I fall into the clutches of another person who convinces me, maybe in my older years, to give it all to them, I could do that and disinherit everybody from the first marriage, the kids from any marriage, and it happens all the time. So you can build in, typically with a trust, remarriage protection.
Now, the technical legal term, there's a couple different terms for it, but we're going to refer to QTIP trust, QTIP trust. That's the tax term when we're talking about remarriage protection.
Right.
But it's powerful. It's very powerful. So, Brad, if you would just explain kind of how remarriage protection works.
Sure. So the estate basically on the first death is divided into two. I got mine, I've got theirs. I can control both parts. But while I can live off their share for the rest of my life, when I pass away, what's left of their share must go the way they wanted it to go, not the way I wanted it to go. I still have control of my share, and I can maybe do with whatever I want to. I can give it to what we earlier agreed on. I can give it to a new spouse, a new love interest. I can give it to charity, as you mentioned, Zach. I have control of my part. I can use their part to support me during the rest of my life, but I cannot give any of their part to another person other than the people they've designated to get it at the second death.
I cannot emphasize how big of a deal this is with blended families. And just to kind of go into a little bit more depth, when the first spouse dies, when you have this QTIP, this remarriage protection in place, the assets split. There's now two trusts instead of one trust. One trust, the deceased person's half of the property goes into. That's the one that has to go to their kids, or however they said before they died. The surviving spouse's half, they can do whatever they want with it. They don't have to give it to your kids. They can give it to their kids. They can give it to a charity. But again, your half is protected. But the surviving spouse still has access to 100% of the property. So that way they can live off of everything. You're not impoverishing your spouse. They still have plenty of assets to take them through these last 10, 15 years. But at the same time, after those 10, 15 years, when that surviving spouse dies, your half still goes to your people. Their half still goes to their people.
Right.
It's powerful.
Okay, Zach, I think we're going to take a break here.
Okay.
And we're going to reconvene in a little while, and we're going to have another couple of episodes of Blended Family here for you. This is a big darn deal. I would say, 40% of our clients are blended families?
Probably about 40.
Yeah. So certainly you may be in a blended family. You may have come from a blended family. It doesn't seem like it should be this hard, and let's make it clear, we don't get to write the law. Governor Abbott is not going to call us and say, Zach, Brad, what do you think the law ought to be on this? Not going to call us. Supreme Court, not going to call us. Trump, not going to call us. So this is just something, again, that you need to be aware of. We're trying to bring this information to you. This book that Zach pointed out is available on our website, texastrustlaw.com. texastrustlaw.com. It's free. And so take advantage of that. There's other books up there too. We've written 5 books. They're all up there, so check them out. And again, remember, free consultation if you want to come into Texas Trust Law and talk about your situation. So I think that's it for right now.
Yep.
Okay. Thank you very much for watching.